People need to understand what ALJs, administrative law judges, and administrative law courts actually do in this system. If you want to talk about unconstitutionality, Article 3 establishes an independent judiciary to protect citizens from loss of life, liberty, and property without due process of law.
I would like to ask this lady a question, because in this video, she says about these administrative law judges being unconstitutional. Now, this sounds really, really good. It does. But either she is absolutely unequivocally ignorant, which means she should not be in office, or she knows she is lying. Because why? Article 1, Section 8, Clause 9 allows the legislature to create these administrative agencies and pass them off to the executive. I mean, the legislature passes the laws that creates them. That's why they're called the legislature. And who enforces those laws? The executive. Now, watch this. Corpus juris secundum, creation of agencies. While in some instances, administrative agencies owe their existence to constitutional provisions, generally they are creatures of statute, and only the legislature has the power to provide for their creation. The states have their own version of Article 1, Section 8, Clause 9 under the federal Constitution. While in some instances administrative agencies owe their existence to constitutional provisions, they are typically creatures of statute, and only the legislature has the powers to provide for their creation. However, the legislature may delegate to governmental subdivisions or agencies the power to create administrative agencies. And where the legislature has placed certain conditions and restrictions on the exercise of the creation power, these conditions and restrictions must be observed if that authority is to be exercised. Now, I'm not going to read that whole thing, but let's go here. Type of agency functions. Executive functions. Administrative agencies are part of the executive branch of government. Administrative agencies are part of the executive branch, and while they often act in quasi-judicial capacity, they wear the robe of judicial authority, but they don't have judicial authority. They are established to perform essentially executive functions. Their functions thus include those of an executive or ministerial nature. Okay? Now, I want to show y'all a court case by the United States Supreme Court called Federal Radio Commission versus General Electric. And the way the Supreme Court lays this out is fascinating. And before any of y'all comment on this video and say it's fraud, you don't know the Constitution if you think it's fraud. Now, we can get into the finer points of how it's supposed to operate, but it's really, at the end of the day, it is contract law. You've signed all these contracts. But let's go to the court case. You can see right here, this is Federal Radio Commission versus General Electric. That's 50 SCT, which is Supreme Court 389. Okay. Look at this paragraph. In the cases just cited, as also in others, it is recognized that the courts of the District of Columbia are not created under the judiciary article of the Constitution, but are legislative courts. Everybody should know the judiciary article is Article 3, and therefore that Congress may invest them with jurisdiction of appeals and proceedings such as have been just described. But this court, which court is that? Article 3, the judiciary, the one that's laid out in Article 3 called the Supreme Court of the United States. Do you remember when Texas sued over voting? Look at the jurisdiction they claimed in that case. They said original jurisdiction. They tell you in their citations what jurisdiction they fall under. If it has ORG, that's original. But this court cannot be invested with jurisdiction of that character. What character are they talking about? Legislative courts. Whether for purpose of review or otherwise, it was brought into being by the judiciary article of the Constitution, is invested with judicial power only, and can have no jurisdiction other than of cases and controversies. That phrase, cases and controversies, is in Article 3. Falling within the classes enumerated in that article, it cannot give decisions which are merely advisory, nor can it exercise or participate in the exercise of functions which are essentially legislative or administrative. Why is that? Separation of powers. The legislature knows what they're doing. That lady is lying to you, just like most of them are. They're acting like this administrative law judges are unconstitutionally doing their job, when they should know if they are any good at their job. And most of the people in the legislature are attorneys, and they should know. They are a creature of the legislative and the executive. So this lady is sitting there putting on this grand show, calling out the ALJs to appease the people, to make it sound like she's doing her job and representing her constituents, when the whole time I'm making the presumption that she knows they are under the control of the legislature and the executive. Take this video for what you think it's worth. I'm just laying out the evidence. I mean, I could lay out a lot more, but we don't want a too long of a video.